So what are we talking about?
Contracts.
What about them?
The legal requirement that when we sell a property that we have to have a contract of sale.
You do. So that's not a legal requirement on the solicitor or the vendor, but it's a requirement of the agent. So essentially, if you want to list a residential property, you need to have a contract prepared.
Yep. That's just for marketing.
Well, for marketing, listing the property, so your agent can't really do anything with your property until they've got the contract.
Yep.
Then they can go on and list the property for you.
Yeah. So we list a property, we do an agency agreement with the owner, and then we send instructions to you. When you receive those instructions, what do you do then?
First thing is get in touch with the vendor, because the vendor's our client as opposed to the agent. So we need to talk to the vendor and say, look, we've got this letter from your agent. You're happy for us to prepare the contract? Because there is a cost involved in preparing a contract,
Sure.
mainly because there are some documents which are called vendor disclosure, which we as your solicitor, as a vendor solicitor, we need to buy those documents from different public authorities so that we can prepare the contract.
Okay.
So we need to touch base with the vendor, make sure they're happy to go ahead, make sure they understand what's involved, and then we get stuck into preparing the contract for them.
Sure. Of course, I mean, obviously we know what those documents are, but explain in layman's terms what each part of the contract and why it's so important.
Yeah, sure. Well, in short, the reason it's so important is because you have to have, it's a regulatory requirement or a statutory requirement for the vendor to include in the contract certain documents. So what that means is, or the consequence of that is, if you don't include those documents, there can be adverse consequences for you as a vendor down the track. So it's a fairly short list of information that you need to provide in the contract. So what's called a property certificate or a title search, which sets out some details about the property, a planning certificate, which sets out some of the relevant planning information, a plumbing certificate, which sets out, or plumbing diagram, which sets out some of the information about the plumbing services around the property. Yeah.
And I assume one of the biggest things is obviously making sure that the house is where it is meant to be. Selling the right property is always handy. Identifying that and identifying any easements over the property.
Well, these documents which comprise the vendor disclosure, they do identify those important things which the vendor is required to disclose when they're selling a property. So there are some things which it might be great for a vendor to set out in a contract, and the purchaser might really want to know those things, but there's no requirement for the vendor to
Sure.
include those things. So like I said before, it's a relatively short list of things that have to be included, and of course the easements and things like that you're talking about, they'll be identified in what's called a deposited plan, and that document is a plan of the property which is obtained from the New South Wales government.
Excellent. Okay. So we've listed the property, we have a contract of sale, we've negotiated the sale on the property. We then issue a sales advice with the purchaser's details. Walk us through what happens then from a legal standpoint.
From my point of view. So the sales advice comes through to us, and once again, we need to touch base with the vendor to go through all the details in that advice and get instructions to update the contract to reflect that sale. So at the earliest step, when we prepare a listing contract or a marketing contract, none of the details are known. We don't know who the purchaser is, we don't know what the price is, we don't know what the deposit is, and we don't know what any of the particular conditions of sale are. So when that sales advice comes through, the agent sets out all of those details. We touch base with the client to confirm all of those details, then we update the contract. So then we have a sale contract that reflects the details of the deal. Following that, it goes across to the purchaser's solicitor, assuming they're instructing a solicitor to act for them. And then we have a period of negotiation. And particularly in our regional area, there is a bit of a delay between the deal being struck, so the key features of the deal being agreed with the vendor and the purchaser via the agent, and the contract being what's called exchanged, which is when the contract is essentially made. And during that period, some of the details are negotiated. For example, there might be clauses which deal with finance or inspections of the property or obtaining approvals for the property, that kind of thing. Because in some cases, some of those considerations haven't been fully explored when the deal is done. and when the price is agreed and those kind of things.
And pest in buildings and all those sort of things.
Yeah, that's right.
Might throw up a curveball that you've got to deal with.
They might throw up a curveball. There might be a delay in getting those inspections done, and in those cases, there needs to be a condition in the contract to allow for those things to happen.
So, assuming everything goes smoothly and we have exchange of contract, so you hand over the purchaser's signed contract to the vendor, and they do the same back. We have exchange. Then there's a 5-day cooling off period unless that's been waived.
Yep, for residential property, yeah. That's
so
right.
then we've got that waiting period between, yes, I've bought it, the sold sticker goes up, everyone's happy.
Yep.
What happens then when you get towards the handing over the keys and what we refer to as settlement?
Yep.
Talk us through those last few days or weeks prior to settlement.
Okay, sure. I think the first thing to go back to is it's really a 2-step process when you're buying a house. So if you consider another kind of contract, usually the contract is made and what's called executed or completed at the same time. For example, you go to JB Hi-Fi to buy a stereo, you look at the stereo, essentially you make an offer to buy it for $500 and they give it to you and you walk out of the store. The contract is made and done in the same moment. When you're buying property, there's 2 stages to it. There's that exchange step that we just talked about, and then there's the settlement step. So the exchange part makes the contract. And the bits of paper really are just evidence for what the agreement is between the parties. And in fact, for land, they're a critical piece of evidence. And then there'll be a period which is called the settlement period or completion period. And round these parts anyway, it's usually 28 days, but there's no magic in 28 days. It might be 42, 35. There's usually a regional practice. So Sydney tends to be 35 or 42. And different regions, for whatever reason, develop these sort of rules of thumb. During that period, there's some work done by the people acting for the vendor and purchaser. They need to check title, make sure it can be transferred free of encumbrances. There's work done behind the scenes with the vendor's bank to make sure that any security on the property can be removed at settlement, and with the purchaser's bank to make sure the money required to buy the property is available at settlement. As we move towards settlement, there's a few things happening from a legal point of view, but one of the key things is the purchaser is well advised to ensure that the property is in the same condition it was when they decided to buy it and when they exchange contracts. So usually we'd see purchasers doing what's called a pre-settlement inspection right up just before the settlement date. So they can go and have a look and say, yep, nothing's broken, nothing's missing, those kind of things.
I'm happy.
From the purchaser's point of view, they probably don't see a lot of what's going on because it's their solicitor and their bank or their broker and the agent that are all working together to make sure the necessary things happen. And we get to the settlement date and there's a flurry of activity. Again, the purchaser doesn't see a lot of that. They need to obviously give the instructions, they're in the driver's seat. But once they give that go-ahead, there's a flurry of activity. Property moves from the vendor's name to purchaser's name. Cash moves from purchaser's name to vendor's name, and you get to hand over the keys.
Yeah, the exciting part.
The exciting part.
Yeah, it's interesting. Obviously, we've been doing it for a while. We get a little bit complacent with the process, and a lot of it does happen secretly. But there is a lot more to it than just those smiling faces and the bottle of wine at the end. But well, thank you for coming in and explaining that. And if anyone has any further questions, don't hesitate to ask the team at Rain and Horn, or of course at Bowerwood.
Yep, absolutely. Happy to.
Thanks, Reece.
Cheers.